Hello students, your topic for today is license. So section 52 deals with the concept of license. When you talk about license, it is that in which one person grants to another person a particular right to do or continue to do something in or upon the immovable property of the grantor. So the grantor is giving the right to do something or continue to do something on his land of which is immovable property, on his property which is immovable, something which he, if he will do without the permission of the grantor, then it will be unlawful. So this is what license is. Such a right shall not amount to an easementary right or creation of interest in the property. So such kind of right is not an easementary right or creation of interest in the property. Essential of licenses: first, there should be a permission granted, right arising out of permission. Second, legalizes an act. Third, is revocable on the act of the grantor. Fourth, always it is in respect of a immovable property. Fifth, it is a right in personam. Revocation of license. License can be revoked in following cases. First, if from the cause of receiving the grant, the grantor himself ceases to have any interest in the property, the license gets revoked. Grantor interest comes to an end. So if the grantor's right is or is ceasing, if the grantor's right is extinguished, automatically the person who's getting the license to do it, licensee will also not have the right over it. Second, by express and implied release of the license by the licensee. If the licensee releases his license by express or implied way, then. Third, there are certain cases where a license is issued under certain conditions or limitations. These includes a license issued on a condition that if a certain act is done or is not performed, then the license may become void. In such situation where these acts are performed, then license can be revoked. Also, licenses are granted for the fulfillment of certain acts, and once it is fulfilled, license can be revoked. So when the license is granted for certain condition or under certain limitations, if those conditions are fulfilled or if the limitations that are provided and if they take place, the condition that he was not supposed to do is performed, then also it will be void and the license will be revoked. Fourth, where a property is in relation to which a license was granted is destroyed due to any reason, then the license is revoked. Fifth, where a licensee himself becomes the owner of the property for which license was granted, then the purpose of which the license was granted ceases to exist, and thus the license also ceases to exist and gets terminated. Sixth, when the licensee does not use it for a period of 20 years, then the license gets revoked. Transferable license. Section 56 of the Act is deals with transferable license. A license can be transferable under the following conditions. First, a license to attend a place of public entertainment may be transferred by the licensee. This may be gathered from the grant or contract or from surrounding circumstances or local usage. For example, P grants Q a right to walk over P's field whenever he pleases. The right is not annexed to any immovable property of Q. The right cannot be transferred. Second, transfer by licensee. The general rule is that the licensee cannot transfer his license. If he transfers, then the transferee becomes a trespasser and can be or may be evicted. Irrevocable licenses. Section 60 deals with the irrevocable licenses. It provides that the license can also be irrevocable. If the license is coupled with a transfer of property and the transfer is in force, then it cannot be revoked. This is subject to the agreement. Hence, the power can be reserved. The rule is that a bare license may be revoked, but if coupled with a transfer of property, then it is irrevocable. A license coupled with an interest in a land is binding. A license coupled with a profit pending is irrevocable. For example, right to excavate earth and carry it to make earthenwares, right to cut and carry timber on payment of royalty. If the licensee has executed some work which is permanent in the nature and has incurred expenses, the license cannot be revoked and hence is irrevocable. Example of this is there are two companies, namely X and Y, having lands adjoining to each other. The agents were common who managed to put up the building and tank on X lands for use by Y. License is irrevocable as the rule applied as was held in Ramson versus Dyson. Difference between license and easement is this, that license is a form of personal right and it is attached to an immovable property, and easement is a right appertinent to immovable property. Second, it is a right of personam. License is a right of personam, easement is a right in rem. Third, the right cannot be attached in license. In easement, it is a right which can be annexed to the property to which it is attached. In license, license is revocable. Easement are not revocable at all. License is the permission given by the licensor, that is the grantor. Easement is acquired as of a right. Thank you.